Greetings, everyone. Welcome to today's webinar. This is Katie Taylor with the AMBA. Hope everybody's having a really good day. We are just going to go through a few housekeeping things. Hopefully, everyone can see my screen. So for today's webinar, we are going to cover avoiding criminal liability views from a former federal prosecutor. Our next webinar that's free is going to be on third-party billing agreements. Is your contract protecting your interests? And that will be on Tuesday, September 10th, and it will start at the same time as our normal time, 11 a.m. Central. For more webinar info, you can go to this website. If you want to learn more about the Liles Parker team, you can go to www.lilesparker.com. So for today's presentation, we're going to do about 50 minutes of content and 10 minutes of Q&A at the end of the presentation, give or take. An email will be sent out an hour after the webinar ends, and it will go to the email address that you used when you registered through GoToWebinar. It'll include links for today's presentation as well as CEU certificates for AMBA, AAPC, and PMI. You must be logged into the webinar online and be viewing the slides to get CEU credit. So just a note on the hour and getting the confirmation email, if we don't end until 12:10 Central, you're not going to get that email until 1:10 Central. So don't freak out. Just give it a few more minutes. So how to participate in today's webinar, we recognize that technology is ever changing and software is ever changing. So we do, have some difficulties from time to time with attendees trying to use the software. If you are joined from the internet, from a internet browser, your view will look like this. Your mic will be disabled. You can raise your hand if you're unable to get to the question screen. The little question mark bubble, that's where you would ask a question. If it's something I can answer during the webinar, I will. If it's a content-related question for Robert or John, I'll save it for the end. And then if you want to look at the handout, click on the little piece of paper. So if you're joined from the software, it will look like this. Again, your mic's disabled. Raise your hand if you need assistance and can't get to the question tab. You can pop down the handouts tab or the question tab. If you're having trouble with your audio on the software, you click on sound check in the top right, and that should help you kind of troubleshoot through it. So we do have our annual national conference coming up in October. We're really excited about it. It's going to be on October 17th and 18th. It's at Planet Hollywood. We are doing a $100 discount right now on registrations. They're $749 for members. Our exhibitor hall is sold out. If you would like to sponsor anything at the conference, you can reach out to Aubrey. We've got a lot of good sponsors on the lineup, and we've got a lot of great speakers. Robert's going to be at the conference, so if you love hearing Robert speak and you've never been able to come to conference, you need to. So we do have conference recordings from the Hawaii conference available for $99, and there's 7 sessions, and it's pre-approved for 7 AMBA CEUs. So for today, we have 2 really great speakers, Robert Liles and John Pierce. They do a really great job for us. A lot of information is presented in a very short amount of time, but they do a really good job of explaining everything and going over that much information. So I'm going to go ahead and turn it over to you guys, and I'd like it if y'all would tell the attendees a little bit more about yourselves too.
Well, thank you, Katie. It's always a pleasure to be here. I'm here today with my friend and longtime partner, John Pierce. And John is the type that he would say, well, I'm just a lawyer. Let me tell you a little bit about John first. John was a federal prosecutor in 3 separate judicial districts. And the way I met John is I used to work with the Attorney General's Advocacy Committee for healthcare fraud. And that is a committee that is comprised solely of presidentially appointed U.S. attorneys around the country whose districts are very active in prosecuting healthcare fraud cases. John, at that time, was an AUSA, an assistant U.S. attorney in the Eastern District of Virginia, and he was doing so much healthcare fraud. His U.S. attorney, presidentially appointed U.S. attorney, rather than her go to the meetings with the Attorney General and that group, she would send John, and that's how I got to know John. So I've worked with John all the way since we both were with the Department of Justice, and I know him to be he was an incredible prosecutor, but he's even better on the defense side, to be honest with you. So that's John's background. John, you want to add anything? Did I miss anything there?
I wasn't doing healthcare fraud.
No. You were managing the prosecution efforts.
Yes, I was a prosecutor handling or coordinating many different agencies in the efforts to control healthcare fraud on behalf of the government. But Robert is the one with all of the abbreviations following his name to show how many accreditations and how much experience he has and why he's so dynamic in the healthcare field. He knows everything, whether it's about the administrative or the civil aspects of the matter, and we're going to talk about criminal aspects of healthcare. But Robert is a well-rounded expert that I'm sure you'll all enjoy hearing from at the upcoming conference.
Thank you, John. Okay, next slide. Before we kind of get into the meat and potatoes of the cases, I ran across this quote from Supreme Court Justice Neil Gorsuch. And, regardless of how you feel about Neil Gorsuch, and there are some strong feelings on both sides of the aisle, even in this room, this is a quote out of his recent book that he just published called Overruled, The Human Toll of Too Much Law. And this is his quote: "Criminal laws have grown so exuberantly and come to cover so much previously innocent conduct that almost anyone can be arrested for something." And I think you would agree with that, wouldn't you, John?
Yeah, so the theme of today's presentation is we're going to try and scare the bejesus out of everybody on this
call.
Well,
no. We're not trying to scare you, but we are trying to let you know this is what's happening.
That's true. It is a reality in the healthcare field that the government has expanded its reach so far that people are swept into criminal investigations and prosecutions that would never have thought they'd landed there. So we don't mean to be extremists about it, but we do want to be able to give you all of the information that you can do your jobs cautiously without ever running afoul of a government investigation, because we have clients day in and day out who do just that. They end up on the wrong side of an investigation and they did not see it coming.
Next slide. Now, I know that we have billers and coders and office managers and other folks from physician practices on this call today. One thing I want to point out is that there really has, over the last, 15 years, maybe 10 years at least, there's been a sea change in how DOJ looks at prosecutions. For instance, this is from a quote from 2021, but the rule is still in place, and they still are very aggressive in this regard. The old days where the DOJ would go after a company and hold the company accountable, and a lot of the principals would be able to just walk away. Those days are over. These days, I can tell you that what the government is focused on now is they're focused on individuals who are involved in the corporate malfeasance. Now, John, this kind of makes sense, doesn't it? Because a corporation is a fictitious person. Technically, a corporation can't violate the law, can it?
Well, that's right. In the old days, a criminal investigation was oftentimes resolved with a quote-unquote plea of guilty by the corporation, and none of the officers had to take responsibility. So the entity would agree to a very large fine for the misconduct, but in the negotiations, the individuals would be cleared. So as Robert mentioned, there's a strong trend away from that, away from entity pleas and trying to hold accountable whoever made the decisions that created the issue that the corporation was involved with. And I make one quick note about politically. I think part of the reason that we have this trend is that when the economy collapsed, really worldwide in 2008, and there were many who thought that there were individuals behind the crisis that the home loan collapse, or the home loan economy collapse caused. And throughout that entire economic collapse, there was one person charged and prosecuted for a financial crime related to that in the United States, just one. So I think that was a big wake-up call to many in the political realm of how should we be dealing with financial crimes, which includes healthcare crimes, and should we be trying to hold the entities accountable, or should we hold accountable the decision makers behind the entities?
And from a billing standpoint, since this is AMBA, of course, from a billing and coding standpoint, just think for a second, who are the individuals that actually end up being responsible for the submission of improper claims? It's going to be the billers who press enter, who actually transmit that claim. So, if you are a part of the problem, the government's going to look at you as being part of wanting you to take part of the responsibility for the bad acts. So you have to be really careful. Next slide. This is more of the same information, but it shows that it goes back all the way to 2015 when they really went forward and they really memorialized this practice all the way back to 2015. And at the time, they called it individual accountability for corporate wrongdoing. Next slide. So it's really important that the physicians, office managers, coders, and billers, you have to really make sure that the submissions that you make to these federal programs, including Medicaid, of course, Medicare, Medicaid, TRICARE, FEHBP, Railroad Retirement, all of these federal and state plans, you have to make sure that, in fact, they're accurate. And from the biller standpoint, we're going to talk about situations that got billers and coders in trouble, even though they weren't the providers themselves. Next slide. All right. This first case. This case was an interesting case. It involved a third-party biller. And the government alleged that the defendants who were providers, if they were billing for either more serious or entirely different claims than those that the doctors performed. So the doctors were performing some services, but the billers billed out something even more than what the doctors were doing. And in fact, in this particular case, it's really kind of crazy. The defendant, third-party billers, made thousands of calls in which they impersonated patients and patients' relatives in order to induce their insurance companies to reconsider denied claims. Now, obviously, the conduct here is over the top. The federal jury convicted the defendant of healthcare fraud, conspiracy to healthcare fraud, wire fraud, and aggravated identity theft. 12 years in prison. Any comments about this one, John? I mean, this one's unique in the sense that in this particular case, the docs were not at all at fault. It was the billers that were actually going out and were messing with the claims.
I think the moral of the story in a case like this is you just have to be honest. You can't go over the top and present false information that people rely on. That's what a fraud is. It's providing information that somebody relies upon to make a decision that's false. So as long as you're providing accurate information, and I think another moral of the story is, make sure that there's communication between you and your clients or the practices, the physicians. If in a case like this, if the insurance companies are not going to approve the claims, and the biller's trying to help by saying, well, let's pretend that we're going to be family members and patients and whatnot and put pressure on them, that's just providing false information. And if your physician or physician practice is asking you to do that, that's where you say, you know what, that's not my job. Yeah. My job is to submit accurate information on claims, and I'll take whatever accurate information you have and I'll submit that. But I'm not going to go above and beyond and do something else that's outside the scope of my responsibilities.
Now, you have to think, what was the motivation of the billing company here? Normally, I would say it's because they get a percentage, so they want the numbers to be up. But New York, of course, is a state where they're not supposed to even be charging percentages. Unfortunately, the information available didn't really disclose what in the world the billing company was doing or why they were doing it, really. In this Illinois case, this is an interesting case, and I'm going to be kind of harping on this issue, the next two cases, Illinois and Alabama, okay? Both involved situations where they were billing for services either not rendered or they weren't rendered as billed. And, you know, the problem is they went after the billers in both these cases because, well, they cited this. I don't know if it's not the sole reason, but they cited the fact that the biller was paid a percentage of the total billings paid to the physician from Medicare in Illinois, and in Alabama they called it a 10% commission. The point is, you know, depending on the state, of course, there is no federal rule that says that you can't be paid a percentage. There are some states that restrict it and where you absolutely can't do it, such as New York. But in these particular cases, they looked at the percentage as the motivation for the biller to be engaging in bad conduct. So, you know, I know that for 20 years now, Cindy and I both have been trying to tell you, we've got to move away from these percentage-based contracts because they can raise all kinds of problems if there's ever an issue. And these are two cases where that's exactly what happens. Next slide. Okay, these are some of the more interesting cases that are coming up these days. Most of the false diagnosis cases are cases that they brought against the Advantage plans or the Medicaid managed care plans, because of course the way they're paid from the government is, you know, there's all kinds of calculations that are based on the acuity of the patients and the rest of it. Here, they actually went after the providers, and they said that you know, the providers caused claims to be submitted that had false diagnosis codes. So, you know, one thing that you have to watch out for is whether it's the provider putting down for you what the diagnosis codes, or if you're responsible for going through the files and adding those diagnosis codes, you need to make sure that there is support before you put any diagnosis code on that 1500. Okay? Next slide. Provider identity. This is a situation, the first one in Michigan. There was a physician who was suspended. Now, keep in mind, just because someone is suspended from Medicare does not mean that they can't still see patients and treat patients. It's just any monies that they would normally receive goes into an escrow account. Well, in this particular case, there was a suspended physician, and he knew that he could see Medicare patients, but he wasn't going to get the money. So he talked to one of his buddies and convinced another doctor who was not suspended, convinced him to enroll in Medicare. And then he would provide services, but he billed everything under the other physician's number and name. Okay, so that's fraud. And the physician was sentenced to 7 years in prison. Okay. It's an interesting case because I mean, there was no law against him as a suspended physician from Medicare. He could still see patients. He could still treat patients. It was the lie that he committed when he billed for those services under another physician's name that got him in all the trouble.
And something I want to point out about the last few cases that you've discussed, Robert, is that in the false claims arena, the same conduct that could become a civil false claim case that may include a multiplier of the loss of 2 or 3 times as a potential recovery for the government, that same conduct could also be prosecuted. So the submission of false information on a claim to the federal government, it could be it could be pursued civilly or it could be pursued criminally. And if the biller or the coder has some role in helping create or submit false information that the coder biller knew was false, they can be in the suit on certainly in the criminal case and even potentially in a civil false claims case. And the other warning that we have to give is that some jurisdictions, let's take the Fifth Circuit in the federal government, that includes Texas, it includes Louisiana, it includes Oklahoma, if I'm not mistaken, or maybe that's the 7th. In any event, in the Fifth Circuit and other circuits, willful blindness is also a means of the government proving knowledge by somebody involved in a false claim. So that what the government will argue, what they're entitled to allege and prove, is that had the person inquired as to what the facts are, if the facts were readily available to them about what's the information being submitted, is it true or is it false, and they were deliberately ignorant about that information, that's sufficient to prove knowledge and intent in the criminal setting. So you can't just try to please your customer by looking the other way. If you know information isn't accurate, you shouldn't be involved in submitting the claims because there's exposure there. You never see it coming, but believe me, we have clients every day who look the other way, and now the government wants to put them under the criminal microscope.
Yes. Cases involving billing for services not rendered. I put this DC case up here because it really stands for the proposition of, the governments are going to dig in deep. In this particular case, this provider supposedly billed for injections that he didn't perform, and didn't even have the equipment to perform. And the reason I bring this up is because we've had several cases where one of the first things the government does is they want to get all your receipts for certain medications or certain supplies, if you have a balloon sinuplasty, they want to, and you billed the government for 50 of these procedures, they want to see, did you actually buy the supplies for 50 procedures? And in fact, there was a lady in North Carolina about this time last year that the government said that she didn't. Turned out she was using the same balloon for multiple people, and they convicted her of fraud and went after her. But the point though is, the government won't just assume if you're billing for services that require injections of certain medications or the use of supplies, the government's not dumb. They're going to go and they're going to want proof that in fact you actually had the equipment to perform these procedures and the supplies as well to perform these procedures. Cases involving forgery of medical records. We see some of these kinds of cases, but they don't come up that often. In this particular case, an unlicensed medical assistant conspired with the owners of 2 home health agencies and forged the physician employer's signature on the certification form. So, that's something that the government looks at. They will actually look at those signatures, and it's not at all uncommon for them to ask for exemplars in an audit. They want samples of all the people that took care of these patients or ordered services or signed off on certifications, they want to see examples of their signature. And if they don't match up, that's going to be another area they're going to dig into. Next slide.
And real quickly, Robert, something that Robert and I see all the time is providers who are poor at record keeping. And so they know they did the work, but they didn't document it well. And so they go back and try to create the documentation to support claims that they submitted. Well, that's going to be considered fraudulent. You have to generate such records simultaneous with the services provided, because if you go back and try to create them, you're going to get the providers are going to be in trouble for fabricating records that didn't exist at the time the services were provided.
Incident 2. Now, Incident 2 is a special area. I'll tell you. The first Incident 2 rules were set up in 1977. So we're talking about now almost 50 years that the rules have been around, and docs still don't get it right. Okay? And that's one of the reasons why I routinely tell people, get everybody credentialed, bill under their own NPIs. Don't bill at Incident 2, because chances are you're not going to do it correctly. Most Incident 2 cases are handled administratively. Some Incident 2 cases have been handled under the False Claims Act. This particular Incident 2 case, though, I raised it because they went after him criminally. Okay, so that just kind of goes to show you, and this is a very recent case. It just happened about less than a month ago. Okay, and in this case, they billed for Incident 2 services that were supposedly provided by a physician when the physician wasn't there, probably didn't meet the supervision requirements of direct supervision. Anyway, in this case, the defendant pled guilty, admitted to losses of at least $3.7 million, and currently faces 10 years in jail. Now, the reason why Incident 2 is also problematic for billers, okay, is that many times we've seen situations where the nurse practitioner isn't credentialed, a service comes through, and the biller just assumes, oh, okay, well, I'm sure Dr. Jones was there, so we can bill it under his number, Incident 2. You cannot assume that, in fact, Dr. Jones was, in fact, in the suite during the period to provide the direct supervision to the non-credentialed nurse practitioner. You just can't assume that. You have to make sure, billers, that before you bill out anything Incident 2, you got to take some kind of steps to make sure that the requirements for Incident 2 were, in fact, met. Okay?
And what the government does, a lot of these cases, of course, arise out of whistleblowers. And a whistleblower will tell a government investigator, hey, that was billed Incident 2, and that doctor was out of the country. So the first thing that the government will do is they'll check travel records. And if claims go in under a physician's name and he's not even in the country, they're going to turn that into a criminal investigation in a hurry.
Exactly. Now, the next case, unlicensed personnel. I thought this was a very interesting case. New York case. They talked about the fact that they had unlicensed personnel and they were billing out their services under the number of a licensed credentialed physician. Okay. What they don't talk about, though, is that in other cases like this that I've seen, what happens is you have someone who is an FMG, a foreign medical graduate, and it could be that they've just come into this country, they haven't taken the test yet so that they can be licensed in the United States, but they're very smart. They are qualified in their country, but they're not qualified over here. And we've seen situations where their services were billed out as if they were a licensed physician, but obviously they're not credentialed, so they have to bill them out under somebody else's number, and that ends up being a real problem. So you got to be really careful, because just because they have the skills, they have the knowledge, doesn't mean that they're supposed to be taking care of patients, frankly. I mean, you really can't allow them to even do NP work or physician work, and you sure can't bill it out. Next slide. Now, one of the statutes, we're going to talk now about the statutes that kind of come up when it comes to physician-related cases. One of the statutes that comes up frequently is the anti-kickback statute. And the anti-kickback statute is, it started out, frankly, it's been around since '72. It started out as a misdemeanor, and it also started out where they didn't really even address intent or knowledge. Okay, so in the beginning, of course, it was not something that providers really had to worry a whole lot about. They made changes to it though in 1980, and they added in proof that you had to show proof of knowing and willful conduct. Next slide. Now that then changed under the Affordable Care Act, and under the Affordable Care Act, they took the other language that was knowing and willful conduct, and they said that a person need not have actual knowledge or specific intent, and that kind of waters it down or makes it easier, I think, for the government to kind of make these allegations. John, what do you think?
Well, we end up representing people in all kinds of areas under an anti-kickback investigation. And for instance, if it's somebody who worked in marketing and their job was to find Medicare eligible patients to pass on to, let's say, a lab or a practice for a patient base. And if they're paid a percentage, that's considered a kickback. And somebody that just thinks that they're doing what their boss told them to do gets pulled into a kickback investigation. And particularly, what we frequently see is the contract will be written in a way that they're being paid just a flat rate for marketing services instead of a percentage of the number of people that they refer. And it's that knowledge of, well, okay, I was paid a little bit differently than what the form says or the claim says, but I didn't know that was wrong. But that's an example of where you don't have to have actual knowledge or specific intent to violate the false claim. You just have to know that something you did was wrong. And if just disclosing or reporting a methodology of payment, that's enough without knowledge of what was actually happening on the other end of this medical transaction. Well, I didn't know that what I was doing was finding Medicare beneficiaries for a back brace that wasn't actually needed. But I was just providing the beneficiaries information for the doctor or the lab to contact later. So you don't have to know that what they were doing was, in the end, selling a back brace that wasn't necessary. You just have to know that you were contributing to the fraudulent submission by an agreement that wasn't true, being paid a kickback instead of being paid a flat rate.
Next slide. Now, the kickback statute, it's extraordinarily broad. The problem with the kickback statute is that you can have a sentence up to 10 years now, the fine up to $100,000. You can be excluded. They can assess CMPs up to $50,000 per violation. And the courts have said that if only one purpose of the conduct was a violation of the kickback statute, in other words, an effort to violate the statute, it can be a violation and they can go after you. And they talk about even if the payments were also intended to compensate for professional services. Part of the problem with the kickback statute is it is written so broadly that practically any kind of a conduct when it comes to business relationships, if you're not careful, you can violate that statute. And in fact, they've issued so many safe harbors under the statute. There are currently, I think, 10 statutory safe harbors and 36 or so regulatory safe harbors. So, that kind of tells you when there are that many problems with the statute that you have to have all these exceptions to it, all these safe harbors for it, that kind of tells you how broad the statute really is.
The theory behind the kickback statute, of course, is that what the government wants is they want the patient-doctor relationship to be unimpacted by any outside influences. So they want a doctor to diagnose a patient condition and address it solely based on the doctor's medical knowledge. They don't want there to be any outside factor to influence that doctor's decision. They don't want, for instance, a supplier of a drug that could be prescribed along with another version of that drug, by another manufacturer. They don't want the doctor's decision impacted by the fact that one of the manufacturers took the doctor on a cruise. So he's being influenced for that decision in the eyes of the government by outside sources. So that's the theory behind it, and that's why with this expanded interpretation of it, any kind of conduct could potentially be seen as influencing that provider's decision.
And there is no de minimis under the anti-kickback statute. It's not like anything over $50 could trigger it. There is, technically that fruit basket that someone sends, and you send it out to them, or they send it to you because you send them referrals or they send you referrals. Technically, that could be construed as a violation. Now, is the government going to go after somebody for a fruit basket at Christmas? No. But you just need to understand what the risks are. Next statute, or next slide, please. The anti-kickback statute, when they passed the Affordable Care Act, one of the changes that they made is they made it to where the anti-kickback statute can still be pursued criminally, but it could also be used to bring a False Claims Act violation. So violations of the anti-kickback statute can be pursued civilly, as you indicated earlier. Next slide. Now, just very quickly, some of the other statutes that come up, some of the other criminal statutes, John?
The healthcare fraud was codified as its own statute. I want to say it was in the 90s. And the government's only adding additional statutes since then. So now healthcare fraud conspiracy has its own statute number. But there are, any type of conduct that involves a submission of false information to be paid for a healthcare service can fall under this 1347 statute. So it can be very broad.
And it's not limited to federal programs.
Right. It's any payer of healthcare services. If there's any false information being provided to induce that payment, that can be considered healthcare fraud.
Okay. How about obstruction?
Well, obstruction is, this is obstruction of a federal audit. Again, the government wants to know that it is being provided accurate information, and if it's pursuant to an audit, they want it to be readily provided, so that if there are efforts to coordinate being non-responsive in a request for documents, for instance, then the obstruction of the investigation can be part of the crime as well. So if there are records, for instance, that the government asks from a billing company that support claims being submitted by a provider, if the provider tells a billing company, hey, hold off on turning those over. We want to look at some things, and if that's part of a course of conduct to deny the government with the information it's entitled to, then the billing company can get in trouble for the obstruction of the audit.
And I think it's important to point out that the term federal auditor means any person employed, full or part-time or contractual basis, to perform an audit or QA inspection on behalf of the government. So that would include RACs and SMRCs and UPICs, wouldn't it?
Right. I mean, they're contractors.
They're contractors.
They're not government employees, but they're working on behalf of the federal government in their roles.
So you got to really be careful, because you do not want to mislead them or impede their audit. Next slide. Aggravated identity theft. This was a bigger deal a few years ago, well, before 2023 than it is today, okay? Almost a year ago today, the Supreme Court came out and said that you can't be using this in every one of your cases. The crux of the fraud has to involve identity theft. What was happening before was they were throwing aggravated identity theft on just about every healthcare fraud indictment, because they said, well, you submitted false claims and you used somebody's identity associated with that false claim, and therefore you committed aggravated identity theft. What they were really doing, though, it was a pressure point that the prosecutors were using, because anytime you have an aggravated identity theft count, if they're convicted of that, that's an additional 2 years on any other period of imprisonment that could be sentenced by the court. Okay? So, they were using this, frankly, I believe, to try to really leverage a plea in some cases.
That's right. They would drop the 2-year exposure in exchange for a plea, oftentimes. And the problem here, of course, is that every patient has an identity, and every claim for services to a patient, it means that you use that patient's identity as part of the claim. So that's where the government was going with it. Not as much of an issue anymore.
That's right. Thank you. Thank you. All right, next slide. Very quickly, false claims. We're all familiar with the Civil False Claims Act. Well, there's a Criminal False Claims Act as well. So you have to kind of be careful, because, depending on the facts in a case, the government could say, you know what, we're not even going to pursue this civilly. We're going to go under false claims under 287 and pursue it criminally.
This kind of goes back to what you were talking about, Justice Gorsuch's quote. There are so many crimes now on the books, and there's so many ways to charge the same conduct that it really is pretty extraordinary. And sometimes you see the government charge it one way, and sometimes you see it charged another, and it's all the same conduct. So there's just a lot of ways to scoop up people in the criminal codes. And as an example, the 1001 down there at the bottom of the slide, that's just making a false statement to a government officer. So the easiest example of this one is the Martha Stewart case, where she was being investigated for insider trading, which is a violation of the securities laws. And she lied to the agent that was investigating the insider trading, and that's what she got prosecuted for. So just like the old adage says, the cover-up is worse than the crime. So that's what 1001 is. They can, even if you didn't do anything, if you make false statements while the government is investigating conduct, then you can get charged with 1001.
Next slide. Billing for services not rendered, pretty straightforward. Not really much to say about those. the government can there's a bunch of ways they can figure that out. One of the ways, of course, is if it's something that involves some type of services involving supplies, they just go back and check: did you actually use the supplies? Did you have the supplies? Did you even have the equipment to conduct a certain procedure? Misrepresentation of a non-covered service. You know, this happens a bunch these days, unfortunately. Just as an example, when it comes to our friends in our chiropractor friends, there's only 3 services that they can perform that are actually billable to Medicare. Well, there have been cases where they performed other services and they billed it out as if it was a covered service. Okay, so that's a real problem. You have to make sure that what you're actually billing for is what was actually performed. Okay,
And oftentimes, of course, the provider is doing it really on behalf of the patient. So the patient has insurance coverage for whatever was provided. And so even though the provider may be trying to help the patient financially, they can get themselves into a problem because they're providing false information on their claim.
Yes. Misrepresentation of the provider of the medical service. This is kind of kissing cousins to Instant 2 in some respects. But we see this a lot where credentialing has taken a long time. They've brought a provider on service. They just cannot, for whatever reason, get it together and get them credentialed. And in the meantime, they can't have them just sitting around while they're having to pay them. So they bill them out under somebody else's number. That can be a real problem. And prosecutors, depending on how aggressive they are, they will either look at it as a bad Instant 2 case, or they could look at it as something more serious. They could consider it wire fraud or even healthcare fraud. So you have to really be careful. Next slide. Okay. Now, one thing we want to talk about, who's going to investigate these cases? Well, if you are investigated, it's not uncommon for the FBI to show up these days, or it could be 2 OIG agents. But let's just talk about the FBI for now. When the FBI comes together, for many years, there was no requirement at all that they record the interviews. They actually issued guidance at one point that said that they weren't to record them. When finally that was criticized in the last few years, they issued guidance saying, well, we're going to start recording. But from our experience seeing cases, that still hadn't occurred. What happens is they'll come in, they'll have 2 agents that come in, and they will interview you. Well, when they leave out of there, they fill out what's known as a 302. And unfortunately, what they put down, that's their interpretation of what was said at the time, isn't it, John?
Yeah, the moral of the story is, and we want to save time for questions, so I'll just make this brief. But the moral of the story is that anytime any government investigator, FBI or otherwise, comes to talk to you, it's going to be part of some kind of investigation. It's always safest to say, happy to talk to you. Just want to make sure that coordinate this with counsel and have them here as well. Because there's 2 agents and you sitting in a room and the agent's not recording it and they're just taking some notes and you don't have somebody taking notes for you, then something that you're sure you said that wasn't significant enough to the listener to write it down, that's not going to be recorded as having happened, at least not with the FBI. So just be careful and know that whatever you say to a government agent, you're not in custody. They don't have to give you Miranda warnings. Whatever you say, it can be used as evidence. Yeah. So you're much better saying happy to cooperate, want to make sure I do it, with the assistance of counsel, and then you make sure that an attorney is involved with the discussion. And frankly, the attorney is going to take over the discussions with the government and coordinate any kind of an interview that you ultimately engage in.
Next slide. I put this slide up there because this shows what can go wrong. This is a case out of last November, not even a year ago, out of Spokane, Washington. And the government was investigating a provider for his controlled substance prescribing practices. Okay? And one of the questions that they asked him when they were interviewing him is they said, how often, before you prescribe somebody opioids, how often do you check their vital signs? And at that time, and this quote is from the government's press release. At that time, he said, 99.99% of the time, I check the vital signs of the patient before prescribing an opioid medication. Okay? Now, I think any reasonable person would think that that's just hyperbole. He's just off the cuff. This is what I think I was doing. Well, it turned out that when they went through all the allegations against him, they couldn't find any billing violations that they could charge, really, and any opioid prescribing violations. They didn't want to push forward with those. But what they did go back to is they went back to that statement of 99.99% of the time. And in the press release, they said, indeed, the rate at which the clinic performed was materially lower. Wow. So they didn't have anything of substance to go after him, but they said that he lied, made a false statement to the FBI based on this exaggeration or hyperbole that he made just off the cuff. You have anything to say about that one, John?
I want to say the same thing as I said before. It's really hard to tell an investigator when they say, can we talk to you? And you don't think you've done anything wrong. It's really hard to say, I'm happy to do it, but I just want to make sure that I have an opportunity to have my attorney here. But you have to be strong, and you have to say, no, I'm not going to talk with you if you're conducting an investigation until I know more. And so, again, happy to cooperate, just can't do it right now.
Yep. Next slide. So what do you do if you find yourself in a position where you think the provider is doing something wrong? Well, the first thing you have to do, of course, is go to them and say, I don't think this is correct. And, at that point, the provider, the healthcare provider, the office manager, should sit down and research the issue. If they're wrong, they ought to come back and tell you, well, we disagree with what you're saying about the billing or the coding or the documentation for the following reasons. If they don't do that, or if they refuse to take some type of remedial action, you go to them and you tell them, we keep billing for Instant 2 and none of these Instant 2 requirements are met. And here's why they aren't, because there's a litany of requirements under Instant 2 that they're not meeting. Can you continue to work at the place and continue to kind of, participate in the fraud? No, you can't do that. So that option, the first option, is just not going to work. Can you lodge your disagreement with management and just say, I've told you guys you're doing it wrong, and they tell you, well, you're going to do it how we tell you. No, you can't continue to do that. You can resign from your position if they refuse to take remedial action, and you can resign from your position and you can file a complaint with the payers if you want to. But then the question comes up, well, do I have to turn my provider in? Well, that's a good question. There is no squealer statute out there. If you see a friend running out of a bank and the alarm's going off and they got a big bag of money and you're just sitting across the street, you don't have any kind of legal obligation to pick up the phone and tell the cops, hey, I saw the guy who did it and I know who it is. But if you conceal and do not make as soon as possible this known to the government that this crime has committed, then you're a party to it, and they can get you for misprision of a felony.
Well, in this context, it's really if you're submitting claims on behalf of a provider, and you know that there's something wrong, and you say, well, I'm going to quit. I can't do this anymore. This is wrong. Well, if there ever is an investigation, and they go back to, X period of time, and here was the person submitting the claims, and then the claims were wrong, and they can then prove knowledge that the person submitting the claims knew they were wrong, then you can find yourself the subject of an investigation, and, all you're going to be able to say is, yeah, I knew it was wrong, so I quit, and hope that means that the government doesn't consider you complicit with the conduct while you were there.
And what about, John, what about you work up a letter and you tell them, I disagree with your position on this particular claims. I recommend that you go back and you make a repayment for overpayments for all of the claims that have been billed incorrectly. And you send that letter to them, and you keep a copy of the letter.
Yeah, anytime you have communications, particularly about what you think is misconduct, it's really important to document what that conduct was and your position about it. If it's in an email, if it's in a letter, just protect yourself with documentation. Of course, we're always here to tell you, go talk to your lawyer and you'll get more complete advice, but always document communications that you think are important about conduct that you think may or may not be correct.
Next slide. So what are the messages you can take from today? Well, just remember, the government is focusing on the individuals that were involved in the improper conduct. You know, it's something that you have to keep in mind. They're not just going to go after the company. If your fingerprints are on those bad claims, they're going to go after not just the providers, but possibly you too. You need to be documenting your efforts to comply with all the rules. And to the extent that you find that there's no repayment, you have to go to the provider and tell them, we have to pay this back. Any closing comments, John?
I think my closing comments are, be happy to take questions.
Okay, next slide. There we go. Any questions, Katie?
So we do have one question. Somebody had asked, you guys talk about not billing on a percentage, and we've been saying that for a lot of years. What does that look like when y'all work with somebody that is charging correctly?
Well, there are a bunch of ways to do contracts that are not based on a percentage. I mean, you could do it based on a flat fee, and the flat fee could be determined. Really, the person to really ask this is next month when you talk to Richard Pecor, when he talks about the billing contracts. But there are different ways that you can structure flat fees that actually reflect the volume of claims that are being processed and the complexity and the rest of it. There are ways to do a flat fee that can be adjusted in case the practice brings on more billing providers, but the government just doesn't like percentages. They just don't like it. That's the one. Yeah.
I was going to say, and if people just really do a good analysis of the practice that they're looking at pricing, you consider factors like how hard is it to file these claims?
Yep.
Like how many denials are they getting on average per month?
And frankly, providers like flat fee too, because it's something that they know, okay, well, this is what I'm going to be paying. They can better do their budget and they know what, going into it, what it's going to cost.
Yeah. And another question we have that came through is, where is the best place to look for the guidelines for billing incident 2?
Oh gosh, the best place to look. Well, I can send, if that person will email me, I can send them the statutory provisions for Instant 2 for Medicare, okay? But keep in mind, they're only for Medicare. Every payer handles Instant 2 differently, and every Medicaid payer handles it differently. So it varies from state to state. Some state Medicaids recognize Instant 2. Some of them, like Texas, they call it Instant 2, but when you look at it, it's not really Instant 2 because the billing provider has to be directly involved in the care. So that's, why is that Instant 2? But if they'll email me, I can send them the provisions that would cover Medicare.
I really appreciate that, Robert, and I sent them your email, so they should be able to reach out. Let's look. We have one more question, maybe. Let me just read it real quick. So this person is asking, this may be a little too specific, but if the provider is not, like they're using the not specified ICD-10 codes for the diagnoses instead of like fully picking the right code and drilling down.
Yep.
And if the bill reading the notes to find the more specified ICD and applying it to the super bill, is the end note documentation satisfactory for my use?
Well, I would stay away from those codes if I could, because that's exactly the kind of code that leads to audits.
So I think the best thing too is to always have the provider, do provider training and try to get them to use the correct codes and
Yes.
have them over any new ones that you think should be replacing what they listed. Let's see here. Okay, if the provider does not personally perform services, but physician assistant does, and instead, however, that provider bills all the services under his or her name and co-signs the medical records, would it be considered as incident to MET?
I'd have to look what the rules are for Incident 2 covering medical assistance and those things. I really just focus on NPs and PAs. But there are other situations under the rules. Under the Medicare Benefit Policy Manual, they have a list of all the different physicians that you can bill Incident 2 for their services.
Okay, we have one more question, and this is actually a really good question. What is the look-back period? Does it ever differ based on the alleged infraction?
That's a great question. John, what's the standard statute of limitations for criminal violations?
Well, the standard statute of limitations in federal fraud prosecutions is 5 years, but invariably the government is going to charge, the fraud is a scheme, and there's oftentimes charges of conspiracy involved with it. So the statute isn't going to start to run until the last act in furtherance of the scheme or the conspiracy. So it might be billing conduct that goes from 2010 to 2019, and it's going to be that conduct in November of 19 that's going to trigger the 5 years. So all of that period is going to be swept up and within the statute for the look back.
Now, on the civil side, under the False Claims Act, it's 6 years or 3 years after the government learns about it, up to a maximum of 10 years. Now, the look back for administrative audits, CMS wants you to go back 6 years.
Thank y'all for that clarification and for explaining it the way that y'all did. That's very helpful. I think that's all the questions that we have for today. Excellent job, Robert and John. Lots of great information. I'm sure you did scare the bejesus out of everyone, but I was laughing at the beginning when John said that.
I didn't mean to be an alarmist, but I knew we were going to get into material that would be alarming.
The only thing that I would like to add before we leave is be careful. Just because you're following the federal rules, especially if you're dealing with Medicaid, make sure you're following the state rules as well, or with private payers. Understand what are the limitations for each one of those sets of claims.
Perfect advice. Again, thank you guys. Thank you for everyone for attending today. We really appreciate your continued support of our organization and Liles Parker. And if nobody has anything else, I'll let everybody get along with their day.
Thank you for having
Thank
us,
you.
Katie.
Thank you, Katie.
Thanks, y'all. Have a good day. Bye-bye.